We did it 3 weeks ago with the Abortion on Demand Until Birth Act, and we're doing it again today. I wonder why this is. Oh, that's right. It's because holding these sham hearings is nothing more than an unapologetic ploy to give the media something to talk about other than the Democratic Party's policy failures and lack of action when it comes to agreeing on how to govern in the best interest of the people. We are facing an inflation crisis, and President Biden and his allies in Congress are carelessly adding fuel to the inflationary fire by advancing their $1.2 trillion, only 9% infrastructure bill and $4.3 trillion big government socialist spending package. Hearings such as the one we are holding right now on ERA are neither productive nor are they applicable to the current issues facing our country. Simply put, they hold as much weight as wearing a politically tailored outfit to a star-studded affair. Over the past year, the so-called Equal Rights Amendment has become both a ridiculous fashion statement and a battle cry for many who fail to recognize the progress the United States has made since the 1970s. But this does not change the fact that the ERA is no longer necessary or applicable. The truth that many of my colleagues have ignored is that men and women are already considered equals under the Constitution. In fact, in many states, women are rightfully offered extra protections, such as sex-segregated hospital rooms, prisons, and shelters, protections the ERA would jeopardize. My first question is for Ms. Stepman. Thank you for being here today, ma'am. I appreciate your testimony.
I'm honored to be here. Thank you.
Would you please share briefly with us how the ERA would affect women's safety and privacy through elimination of sex-segregated facilities?
Sure, I'd be happy to do that. I've already mentioned the effect on women's prisons,
Right.
where men and women potentially would have to be integrated within prisons and even prison cells when those cells include more than one person. There are many other consequences, though, if we require the law to be completely blind to the fact that sex differences exist. I also mentioned pat-downs in the airport, bathrooms, locker rooms, any kind of facility that any kind of public school, whether that's on the university level or the K-12 level, has separated for boys and girls. Any sports teams connected to those public schools, which we're already having this conversation, but you know, men jump 25% higher, throw 25% further, run 11% faster, accelerate 20% faster. They punch 30 to 162% harder, and they're overall about 30% stronger than females who are pretty much the same size. So this is to similarly sized females. You know, the ERA in Massachusetts, a state-level ERA, has already made a ruling that boys must be admitted to girls' teams. And again, we're no longer just talking about a small percentage of people who are born one sex and identify as another and who may undergo various kinds of treatments to suppress some of the effects of testosterone. Now we're just talking about regular boys, males, who would then be admitted to compete against women. These are opportunities that women and girls cherish and that we have won over time. And I really think that we are downplaying how many times in our everyday lives as women we rely on the law to allow us, for example, for privacy or safety reasons, to separate ourselves from men temporarily.
Absolutely, and I would never want to take that away from women. That would be unjust to do that. As a follow-up, how would this legislation affect life-affirming healthcare facilities and physicians with religious objections to abortions? Would it have an effect there?
So the ERA's effects on abortion law, there's been quite a debate. There are some proponents who say it does not affect abortion law at all. That hasn't been true in the states. Both New Mexico and Connecticut on state-level ERAs have required under those ERAs that taxpayer funding be applied to abortion. And I'm not specifically familiar with any cases on physician conscience rights, but generally the ERA could provide an alternative basis to continue having a right to abortion in the Constitution. And in fact, most pro-choice groups acknowledge that. For example, NARAL has acknowledged that on their website and has cheered the ERA for that reason.
Okay, thank you. So not only would passage of ERA impose dangerous policies that would strip women of necessary protections, force taxpayer funding of abortion, it would also circumvent the legitimate constitutional amendment process. Differences of opinion and policy aside, the 1972 Equal Rights Amendment deadline expired nearly 4 decades ago. Legislators are attempting to resurrect a dead amendment. Even the late liberal icon, Justice Ruth Bader Ginsburg, noted that the only way the ERA can be added to the Constitution would be to introduce it anew. Even having been a supporter of ERA, Ginsburg recognized there was no path by which you can move forward while simultaneously ignoring the fact that the ratification deadline passed more than 4 decades ago. Even if supporters of this amendment sincerely believe it was still necessary, I imagine they would be willing to follow the guidelines prescribed in the U.S. Constitution, but they're not. Instead, Democrats are choosing to shoehorn through Congress a constitutionally questionable measure. To that end, Madam Chair, I once again implore you to use this committee's limited time and resources to gather expert knowledge on issues that are both current and within the committee's jurisdiction. To do anything else is a shameful waste of our constituents' tax dollars and only allows for more White House policy failures without proper committee oversight. And with that, I yield back, Madam.